All right, welcome back. This morning, jury selection begins in the trial over Elon Musk's infamous 2018 tweet claiming that he had secured funding to take Tesla private at $420 a share.
Now, because of that tweet, investors ended up losing millions of dollars, and now shareholders are suing the tech giant. Joining us now to discuss what we can expect in the case involving the former world's richest man is David Chase, an SEC defense lawyer, managing partner at the David R. Chase law firm, also a former SEC enforcement attorney. He knows this stuff, in other words. David, welcome to Morning Rush. Appreciate your insight here. I know this is a little bit in the financial weeds a little bit, but let's face it, Elon has been in the news for a whole bunch of reasons in recent months, and of course now owns Twitter, which makes this all the more interesting. So, as a former prosecutor for the SEC, what is the biggest challenge for the prosecution in the case? Because the evidence is there. He sent out a tweet. He made a very definitive statement. People reacted to it. So where's the gray area in all this, if there is gray?
So this trial is going to be very, very difficult for Elon Musk and Tesla to win, because the judge, prior to the start of the jury trial, I understand the jury is going to be selected today in San Francisco, has already ruled that Mr. Musk made a false and reckless statement when he tweeted that he was considering to take Tesla public, or private, I should say, at $420 a share, and that funding had been secured. That ruling thus makes really the only issue to be considered by the jury whether or not that false, reckless statement caused a loss in share price for the investors who are suing. And so really the only question was whether that statement, that false statement, was materially false such that it caused the decline in stock price. Remember, the shareholders are essentially suing based upon the inflation of the stock price, based upon the take it private 420 funding secured tweet, along with a few others, and then the fall or decline of the share price a few days later when more information came out into the public and there started to be serious doubts as to the accuracy of that tweet. So the jury's role in this case is really limited to determine whether that false statement caused the fall in stock price, and if so, how much. And so really Tesla and Musk are going into this battle in a sense with one arm tied behind their back.
So with that being said, though, is there any challenge then for the defense's side when it comes to winning this case, although it will be difficult, as you said, for Elon Musk to win?
So I think where the defense is really going to dig in is to basically claim, look, yes, the court has already ruled the statement was false and reckless, but it wasn't material. And materiality is a key element, is a necessary element to prove a securities fraud claim. And basically what I think the defense is going to argue is that there was no real direct correlation or cause between the false tweet and the increase in share price and then the subsequent decline, which I think is going to be a tough argument to make. But remember, there's a lot of other information out there in the market that can drive or drove Tesla's stock price. There's not only specific company information, but there's also macro kind of economic news in the market that could affect Tesla as well as the other prices of other stocks as well. So this will become very much a battle of the experts. Both the plaintiffs and Tesla and Musk on the defense have their own experts who have done impact studies, if you will, on the price of stock as, either driven or not by that false tweet. And so the experts are going to be testifying, and then ultimately it's going to be up to the jury to make a determination and then ultimately determine how much, if at all, shareholders have lost because of this.
Two-part final question. Number one, I would assume, particularly for the prosecution, that it's a beautiful thing these days that everything is time-stamped on your phone. I'm sure at some point a lawyer will say, Elon sent that tweet at blah, blah, blah time, and then watch what the stock did right after that tweet went out and can kind of track it all in real time. I would imagine that will be Exhibit A at some point during this trial. Ultimately, though, what happens to Musk and to Tesla if he's found guilty? How much is on the line? Could this really damage someone of Musk's unarguable power and wealth?
Right. So this is a civil trial, and at the end of the day, it's about money. It's about how much, if at all, have investors lost. Again, investors that purchased the stock within a certain time frame and sold within a time frame. So it's just about money. Plaintiffs are arguing that the losses, as I understand it, could be in the billions of dollars. That's with a B. And the defense is going to attempt to argue that there's no materiality component and thus there's no damages. But I think as a practical matter, if I'm guessing, Tesla and Musk are coming into this with the strategic goal of trying to reduce or limit the amount of damages. But at the end of the day, if things go wrong for Tesla and Musk, he's got plenty of money. And I don't think this is going to materially fundamentally change his financial condition. And that's why I think, in part, you see this going to trial, because most companies, publicly traded companies, once they lose a motion to dismiss or a motion for summary judgment on the issue that I mentioned, meaning that the court has already found that he made a false statement, they usually settle. But Mr. Musk and Tesla are not your usual company and CEO. And so this is unique in that sense, and I think it's just going to be a fight about limiting the amount of damages to be awarded by the jury.
All right, David Chase, an SEC defense lawyer and managing partner at the David R. Chase Law Firm. Thank you so much.